Hello there, Steve here. Welcome back to another Sleepy Steve story. I hope you are tucked in, comfortable, and warm. Go on. Adjust your pillow if you need to. Let your shoulders drop, and allow the day to slow down around you, because there is absolutely no rush tonight. None at all. Before we drift off tonight, remember to subscribe to help Steve-O out, and I will keep making more sleepy stories to help you study gently, revise quietly, and settle your mind at the end of the day. Now, before we drift off, let's set our coordinates for tonight. We are continuing VCE Legal Studies, Unit 3, Area of Study 1, the Victorian Criminal Justice System. In the last episode, we opened the door to Unit 3 by looking at the broad purpose of the criminal justice system, the difference between summary offenses and indictable offenses, the court hierarchy, the presumption of innocence, the burden of proof, the standard of proof, and the principles of justice, fairness, equality, and access. Tonight, we are going to stay in Unit 3, Area of Study 1, but we are going to move closer to the people inside the system. We are going to look at the rights of an accused person, the rights of victims, and the responsibilities of the key participants in a criminal case. We will move slowly through the role of the police, the prosecution, the defense, the judge, the jury, victims, witnesses, and the court itself, and as we do, we will keep asking a quiet but important question. How do these rights and responsibilities help the criminal justice system achieve fairness, equality, and access? You do not need to write anything down right now. You do not need to force yourself to remember every detail. Just listen and let the ideas become familiar. Imagine that we are sitting again in a quiet study room late in the evening. There is a soft lamp on the desk, a notebook open beside us, and outside the window the street is dark after rain, with the footpath reflecting the glow of the street lights and the trees moving very gently in the night air. Tonight, on the desk, there is a simple drawing of an empty courtroom. There is a place for the judge. There is a place for the jury. There is a place for the accused. There is a place for the prosecution. There is a place for the defense. There is a place for witnesses. And somewhere beyond the formal layout of the courtroom, there are victims, families, supporters, court staff, and members of the wider community, all affected in different ways by what happens inside the criminal justice system. Each place in the courtroom tells us something. Each person has a role. Each role carries responsibilities, and some people have rights that must be protected if the system is going to operate fairly. Take a slow breath in and gently let it go. Let's begin with the accused. The accused is the person who has been charged with a criminal offense. That is a simple definition, but it carries enormous weight, because once a person becomes an accused person, they are drawn into a system that can affect their liberty, their reputation, their family, their work, their education, their mental health, and their future. Because the consequences can be so serious, the criminal justice system recognizes rights for people who have been accused of crimes. These rights are not given because the system assumes every accused person has done nothing wrong. They are given because the system must not punish a person unless guilt has been properly proven through a fair process. One of the most important rights is the right to be presumed innocent until proven guilty. This means that the accused does not begin the process as a guilty person who must win back innocence. The accused begins as innocent in the eyes of the law. and that innocence remains unless the prosecution proves guilt beyond reasonable doubt. This right supports fairness because it protects the accused from being judged too early. It supports equality because every accused person, regardless of background, reputation, wealth, or public opinion, is meant to begin from the same legal starting point. And it supports access because the accused can participate in the system with the protection of a clear legal principle that places the burden of proof on the prosecution. Another important right is the right to silence. The right to silence means that an accused person is not generally required to answer questions or provide information that may help prove the case against them. This connects closely to the presumption of innocence and the burden of proof, because if the prosecution must prove guilt, the accused should not be forced to build the prosecution's case. Silence should not simply be treated as guilt. Silence can be a protection. Silence can be a way of preventing pressure, confusion, intimidation, or unfair self-incrimination. Of course, the right to silence operates within legal rules and particular circumstances, but as a broad principle, it helps protect the accused from being compelled to speak against themselves. The accused also has the right to a fair hearing. A fair hearing means more than simply being placed in a courtroom while other people speak. It means the accused should understand the case against them, have a reasonable opportunity to respond, be able to challenge evidence, and have the matter decided by an impartial and independent decision-maker according to the law. A fair hearing is central to fairness. If an accused person cannot understand what is happening, cannot present their side, cannot test evidence, or cannot rely on the decision-maker to remain neutral, then the system becomes much harder to trust. The accused may also have the right to legal representation. Legal representation matters because criminal law can be complex. The rules of evidence can be difficult. Court procedures can be unfamiliar. The language of the legal system can be formal and intimidating. A defense lawyer can explain the process, advise the accused, test the prosecution's evidence, make submissions, question witnesses, and help ensure the accused's rights are protected. This is especially important when there is an imbalance between the individual accused and the resources of the state. Access to representation can affect fairness, equality, and access because a person with money, confidence, education, and legal knowledge may be in a much stronger position than a person who is poor, young, isolated, unwell, unfamiliar with English, or frightened by the process. So, when we think about the rights of the accused, we are really thinking about safeguards. The presumption of innocence, the burden of proof resting with the prosecution, the right to silence, the right to a fair hearing, the right to legal representation, the right to trial without unreasonable delay, the right to an interpreter where necessary, the right to have the matter heard by an impartial decision-maker. These rights form a quiet circle of protection around the accused, not to make the system easy and not to prevent accountability, but to ensure that accountability only follows a fair process. Let's take another slow breath, in and out. Now let's turn gently towards victims. In a criminal case, a victim is a person who has suffered harm as a result of a crime. That harm may be physical, emotional, psychological, social, financial, or a combination of these. The criminal justice system is not only difficult for accused people, it can also be difficult for victims. who may have experienced harm and then find themselves drawn into a legal process that is formal, slow, confusing, and sometimes distressing. Victims are not usually the party who brings the case in the same way that a plaintiff brings a civil case. In a criminal matter, the prosecution represents the state, but victims still have important rights and interests. Victims should be treated with dignity, respect, and compassion. They should be kept informed about important parts of the process where the law allows or requires it. They may need protection, support, and information. They may be witnesses. They may provide evidence. And if an accused person is found guilty, victims may have the opportunity to provide a victim impact statement to help the court understand the effect of the offending. A victim impact statement can explain how the crime affected the victim physically, emotionally, psychologically, socially, or financially. It does not replace the evidence needed to prove guilt. It does not allow the victim to decide the sentence, but it can help ensure that the harm caused by the offending is recognized when the court considers sentencing. The rights and interests of victims support fairness because victims should not be ignored by the system. They support access because victims may need information, support services, and assistance to participate meaningfully. And they support equality because victims from different backgrounds should be treated with respect and should not be disadvantaged by language, age, disability, trauma, distance, lack of legal knowledge, or fear. At the same time, the system must balance the interests of victims with the rights of the accused. This is important. A criminal trial is not a simple contest between kindness to victims and protection for the accused. A fair system must care about both. It must recognize harm. It must treat victims with dignity. It must also protect the accused from being wrongly convicted. It must allow victims to be supported. It must also maintain the presumption of innocence. It must take harm seriously. It must also require proof beyond reasonable doubt. Justice is careful because these rights and interests must be held together. Now, let's look at the responsibilities of the key participants, beginning with the police. Police are often the first formal part of the criminal justice system that a person encounters. Their responsibilities include investigating alleged offenses, gathering evidence, questioning people where lawful and appropriate, arresting suspects where legal requirements are met, charging people when there is a basis to do so, and helping protect the community. Police have significant powers. They may be able to search, seize, arrest, question, and use force in certain circumstances. Because these powers are significant, they must be exercised according to law. This matters for fairness because the investigation should be conducted properly and without abuse of power. It matters for equality because police powers should not be applied unfairly or discriminatorily. And it matters for access because people who are interacting with police should be able to understand their rights, receive assistance where needed, and be treated according to legal protections. If police gather evidence unlawfully, fail to follow proper procedures, or treat people unfairly, the integrity of the criminal justice system may be affected. But when police act lawfully, carefully, and responsibly, they help the system function by collecting evidence, identifying suspects, protecting victims and the community, and bringing matters before the courts. The next key participant is the prosecution. The prosecution represents the state. In a criminal case, the prosecution has the responsibility to present the case against the accused, call witnesses, lead evidence, make submissions, and attempt to prove the elements of the offense. The prosecution carries the burden of proof. The prosecution must prove the case beyond reasonable doubt. This means the prosecution's role is not simply to win at any cost. A prosecutor must act fairly and according to their duties because the prosecution represents the community and the proper administration of justice. The prosecution should present relevant evidence, assist the court, follow legal rules, and avoid unfairly prejudicing the accused. This supports fairness because the case against the accused should be presented properly. It supports equality because the prosecution must apply the law consistently. And it supports access because clear presentation of the case can help the accused, the court, the jury, victims, and the public understand what is being alleged and what must be proven. Now let's consider the defense. A defense lawyer represents the accused. Their responsibility is to protect the interests of the accused, advise them, test the prosecution's evidence, question witnesses, make legal arguments, and help ensure that the prosecution proves its case according to law. The defense does not need to prove innocence in the ordinary sense. Instead, the defense may challenge whether the prosecution has proven guilt beyond reasonable doubt. This can involve questioning the reliability of witnesses, pointing to gaps in the evidence, raising legal issues, making submissions, or arguing that the prosecution has not met the required standard. The defense plays an important role in fairness because it helps prevent the state from using its power without proper scrutiny. It plays a role in equality because an accused person should not be left powerless against the resources of the prosecution. And it plays a role in access because the accused needs meaningful assistance to participate in the process, particularly when the law is complex and the consequences are serious. Now picture the judge. In a criminal trial, the judge is responsible for ensuring the trial is conducted according to law. The judge manages the courtroom, rules on legal issues, gives directions to the jury where there is one, explains the relevant law, ensures procedures are followed, and may determine the sentence if the accused is found guilty. In a trial with a jury, the judge is the decision-maker on questions of law. The jury is the decision-maker on questions of fact. This means the judge explains the law, while the jury decides whether the prosecution has proven the facts necessary for guilt beyond reasonable doubt. The judge's independence and impartiality are essential. A judge must not favor the prosecution or the defense. A judge must not decide based on personal opinion, public pressure, media attention, or sympathy alone. A judge must apply the law. This supports fairness because the accused and the prosecution should receive a properly managed trial. It supports equality because the law should be applied consistently. And it supports access because clear directions, proper procedures, and careful management can make the process easier to understand and more reliable. Now, let's move to the jury. A jury is used in some criminal trials, particularly for serious indictable offenses when the accused pleads not guilty. The jury's responsibility is to listen to the evidence presented in court, follow the judge's directions about the law, deliberate carefully, and decide whether the accused is guilty or not guilty. The jury must decide based only on the evidence and the law, not rumors, not media reports, not assumptions, not personal prejudice, not sympathy alone. The jury is important because it allows ordinary members of the community to participate in the criminal justice system. It can support fairness by bringing community judgment into serious criminal trials. It can support equality if jurors are selected in a way that reduces bias and if they decide only on the evidence. It can support access by helping the system reflect community involvement rather than leaving every decision to legal professionals. But juries can also raise challenges. Jurors may find complex evidence difficult to understand. They may be affected by unconscious bias. They may be influenced by media coverage if they are not careful. They may struggle with long trials, technical evidence, or difficult legal instructions. That is why the judge's directions are so important. The judge helps guide the jury, explains the law, and reminds jurors of their duty to decide the case only on the evidence presented in court. Now, let's think about witnesses. Witnesses provide evidence in a criminal case. They may have seen something, heard something, experienced something, recorded something, examined something, or provided expert knowledge about a particular issue. Witnesses have a responsibility to tell the truth. Their evidence may be questioned by the prosecution and the defense. This questioning can help test reliability, accuracy, memory, perception, consistency, and credibility. For some witnesses, giving evidence can be stressful, especially if they are vulnerable, young, traumatized, frightened, or connected to the accused or the victim. The system may need to provide support or special arrangements in appropriate circumstances so that witnesses can give evidence as safely and clearly as possible. This connects again to fairness, equality, and access. A fair trial needs reliable evidence. Equality may require support for witnesses who face particular barriers. Access may require procedures that allow people to participate without being overwhelmed or excluded. Now let's return to victims, because victims may also be witnesses, but their role is broader than that. Victims may report the crime, assist police, give statements, provide evidence, attend court, receive information, access support services, and, after a finding of guilt, provide a victim impact statement. The criminal justice system must treat victims with respect, but it must also remember that the victim does not carry the burden of proving the accused guilty. That burden belongs to the prosecution. This distinction matters because criminal cases are brought by the state, not simply by the victim as a private person. The victim's experience is important. The victim's safety is important. The victim's dignity is important. But guilt must still be established through evidence and law. Now, as the room grows a little quieter, let's step back and look at all the participants together. Police investigate and enforce the law. The prosecution presents the case for the state and carries the burden of proof. The defense represents the accused and tests the prosecution case. The judge manages the trial and applies the law. The jury, where used, decides the verdict based on the facts and the evidence. Witnesses provide evidence. Victims may participate, receive support, and have their harm recognized. Court staff help the court operate, and the accused has rights that must be protected throughout the process. Each role matters. Each responsibility matters. And when these roles are performed properly, the criminal justice system is more likely to achieve fairness, equality, and access. But when these roles are not performed properly, problems can arise. If police misuse their powers, fairness may be undermined. If the accused cannot access legal representation, equality may be weakened. If the prosecution does not present the case fairly, the system may lose integrity. If a judge is not impartial, the hearing may not be fair. If a jury is influenced by prejudice or media reporting, the verdict may become unreliable. If victims are not supported, access may be limited and the system may feel distant or harmful. If witnesses cannot give evidence safely or clearly, the search for truth may be affected. This is why Unit 3 does not simply ask us to describe the system. It asks us to evaluate it. When you evaluate, you make a judgment about the extent to which the system achieves its aims or the principles of justice. You might say that a right or responsibility supports fairness because it allows the accused to respond to the case against them. You might say that legal representation supports equality because it reduces the disadvantage faced by an accused person who lacks legal knowledge. You might say that victim support services improve access because they help victims understand and participate in the process. But you might also say that cost, delay, language barriers, trauma, complexity, unconscious bias, media pressure, or limited availability of legal services can reduce the system's ability to achieve fairness, equality, or access. Good legal studies answers often do both. They explain the strength. Then they explain the limitation. They do not simply say the system is fair or unfair. They explain why. They use legal terminology. They connect back to the principles of justice. And they show an understanding that the criminal justice system is trying to balance many different rights, responsibilities, and interests at once. Take a slow breath in and gently let it out. Let's do a soft recap now. The accused has important rights, including the presumption of innocence, the right to silence, the right to a fair hearing, the right to legal representation, and the right to trial without unreasonable delay. Victims have rights and interests, including being treated with dignity and respect, being kept informed where appropriate, accessing support, and having the impact of the crime recognized, particularly through a victim impact statement after a finding of guilt. Police investigate alleged offenses and must use their powers lawfully. The prosecution represents the state and must prove the accused guilty beyond reasonable doubt. The defense represents the accused and tests the prosecution case. The judge manages the trial, applies the law, gives directions and sentences if guilt is established. The jury, where used, decides the verdict based on evidence and the judge's directions. Witnesses provide evidence and must tell the truth. And through all of this, the system should aim to achieve fairness, equality, and access. Fairness means a proper process, a fair hearing, impartial decision-making, and a real opportunity for the accused to respond. Equality means people should be treated equally before the law, while also recognizing that some people may need support to participate on an equal footing. Access means people should be able to understand and use the system, receive advice and support where needed, and participate meaningfully in legal processes. These are the ideas to let rest in your mind tonight. Rights, responsibilities, participants, fairness, equality, access. The room is quiet now. The lamp on the desk is still glowing but softer than before. The rain outside has eased, and the street beyond the window is almost completely still. You have done enough for tonight. You have moved through another important part of Unit 3, and the ideas are now sitting gently in place. You do not need to hold them tightly. You do not need to keep revising. Let the words become quieter. The accused, the victim, the police, the prosecution, the defense, the judge, the jury, the witness, each with a place, each with a role, each part of the system. And now, as your breathing slows and your body becomes heavier, let the legal studies notebook close softly in your imagination. Let the courtroom drawing fade. Let the rain outside become a gentle background sound. Let your mind rest. This has been Sleepy Steve, helping you fall asleep and study. Good night.